to our webinar on the top 10 issues in adoption review and indexing. We are so glad you've joined us today. I'll just say one more time that your last chance, you can click on that link on the slide if you have not yet downloaded the handouts. They are there for you. But we're going to go ahead and get started. As I said, we do know that we're going to have lots more people on with us. For those who didn't hear, we have over 300 people registered for this event, which is wonderful. About 78 folks from the court side and 226 folks from the social worker side, from both county DSS agencies and private child placing agencies. So we're really excited to have all of you participate, and do hope you will use the chat pod, as you've already started to do, to let us know your questions and your comments as we go along, because we know that the more interactive this is, the more interesting it will be for you and the more you'll get out of it. So we really do encourage you to continue to use that chat pod. The goals of this webinar are pretty straightforward. We hope to save you time and make your life easier, so who can't get behind that? Of course, the ultimate goal for everyone working in the area of adoptions is to ensure timely, secure adoptions for the children in our state. So everything we talk about today will be in order to move us towards that goal. Here's our agenda. I'm going to give you a very brief orientation to this webinar platform, and I'm going to introduce our 3 guest speakers, and you can see their lovely smiling faces on your screen. We are then going to talk a little bit about the adoption process and timeline. We'll then go through our top 10 issues. We're going to spend a few minutes on some recent legislative changes that affect adoption, and then we'll have a quick application and closing. But before we go any further, I just want to ask you all, we are going to be presenting our top 10 on adoption, but let me just ask you to chat. What would you say, what is one thing, one issue or concern or question that you have about adoption that you would put on your top 10 for the adoption process? So I'm going to give you a few minutes to type. What's one item you would have on your top 10 for adoption? And we'll let you know whether your top 10 aligns with our top 10 or not. Okay, thank you. Mecklenburg County. Why is it taking 6 months instead of 90 days to receive a decree? After filing the petition, we'll be talking a lot about the timeline, so hopefully we'll be addressing that. Sharita, a question about ICWA. That is a great question. That's not on our top 10 directly, but the other reason we are asking this question is so that we can gather your main issues to help the division and its partners plan future webinars and future learning events. So thank you for sharing that, Sharita. I'm going to give folks a chance. I see lots of folks typing. Yes, and also Jane is just reminding me, we hope to have some time for open Q&A at the end, and so if we do, Sharita, when we get there, if you have a particular question on ICWA, we will do our very best to answer it. You also will have all of the presenters' contact information. I know they're always very gracious about being available by email for questions that we're not able to address during the webinar. And finally, I'll mention that we will be doing a follow-up Q&A document to this webinar as we've done in the past. So again, that both questions that we answer during the webinar, so people have them in writing and can share them with their coworkers, and also questions that we don't get to, we can attempt to get an answer in writing. So thank you all. So let me see what else is coming. Making sure everything matches. We're going to be talking about that. Some of the repetitions on the forms. Okay, great. This is really helpful. So I think a lot of these, and talking about consent, getting consent from the father, notifying the father, so I think a lot of these topics we will be covering, and those that aren't, we will do our best to get you answers to those. So thank you for doing that. Let me say quickly, you've already found the chat pod, so you know this is your main way to communicate with us. I do want to mention one other thing. If you have a technical problem, please do let us know by the chat. As I said, we have some folks on with us to help with the technical issues. If they are trying to respond to you privately, you will see another little box down at the bottom of the chat box. You see on the screen it says everyone and then it says hosts. You would have an extra little tab down there that would say either Philip or John, and it would light up. And that will let you know if our technical folks are trying to respond and problem solve with you. We do also have these fun little icons, which some of you have already seen. If you see up at the top of your screen, you have a couple little pictures, and one of them is the little man waving. And there's a little drop-down arrow, and you can choose one of those little icons. I'm going to put up some applause. But you can also use those if you have want to agree with something or respond to something. That's just another way for you to do that. Okay, let me go ahead and introduce our guest panelists today, and you'll be hearing from all of them. Tammy Johnson was an assistant clerk of Superior Court, and she supervised departments of Juvenile Court, Adoptions, Drug Treatment Court, and Wake County Clerk of Superior Court for 19 years. For the last 9 years, Tammy has managed the adoption program, confidential intermediary services, and adoption review on behalf of the Division of Social Services, and she has recently become the supervisor of the NC Kids program as well. Welcome, Tammy. Let me let you say a quick.
Good morning, everyone. Glad to be here.
Thanks, Tammy. We also have Tracey Duncan with us, and Tracey has been in child welfare for over 21 years. She has worked at the local level as a foster care social worker and later in child protective services with a specialization in sexual abuse forensics. Tracey continued to work in local DSS agencies as a supervisor in CPS and adoptions, and then was a program manager at Easter Seals. She, while there, is when she met and adopted her daughter Tiffany, who is now 14. And shortly after that commitment to adopt, Tracey was offered a position as an adoption consultant at the Division of Social Services. So she was there at the division for about 6.5 years. She has done child and family services reviews and child fatality reviews. And as of September, she is now the lead business analyst for the NCFAST Child Welfare Project. So we could have several webinars, I'm sure, on NCFAST that Tracey could answer questions on. But for today, we'll be focusing on adoption. So let me pause and let...
Good morning, everyone. Happy to be here.
Thanks, Tracey. And finally, we have Jane Thompson. And many of you know Jane. Since 1981, Jane has been one of 4 child welfare attorneys with the Attorney General's Office representing the Division of Social Services. Jane is based in Winston-Salem and consults with county departments, judges, clerks of court, and other agencies in 33 counties regarding child abuse and neglect, termination of parental rights, foster care, adoption, and both federal and state child welfare legislation. So welcome, Jane. Also, we're so glad to have you, and let me...
Yes, I have been around legally forever. That would be correct. I'm always happy to talk about adoption with any of the 100 counties, and really glad to be.
Thank you, Jane. And so I'm going to turn it over now to Tammy to start us off with a review of the adoption process and time.
Good morning, everyone, and we're just going to get started. And as I tell my granddaughter, let's go. We got a lot to cover. So I'm going to start with the process and the timeline, which is a question always asked, and it kind of changes from time to time. But one thing that never changes, once the clerk enters the decree of adoption or disposition, which includes all dismissals, you have to send those to DHHS within 10 days of the final decree or disposition or dismissal. That is a statutory requirement. And one thing I want to address is when it takes longer than that, and sometimes it takes more than 6 months before we get them, it affects our money. Everything that we key in into our adoption information management system is reported biannually to the feds, which is every 6 months. And if we're missing any adoptions that we don't have, we don't get reported, and therefore we don't get our money back from the Fed. So it's very, very important that within 10 days you send the final decree or dismissal to our office. The clerk keeps the original petition and the decree. You can send copies of the petition and the decree along with all the original documents to DHHS. The clerk can keep copies of everything else in their file, but just make sure it's sealed or it's locked if you do that. I think most clerks send everything and only keep the petition and the decree. And please remember that the final decree is public record. Clerks can provide a copy to anyone who requests a copy of the final decree. On mailing the documents to DHHS, you can use courier, but most clerks want proof of receipt that we have received it. If you send it certified mail, make sure if you have multiple records in a packet that you, on the green card, individual, maybe by file number, should be listed on that green card, because sometimes you will send us something and you think a case is in there and it's not, and there's no way of verifying that that case is in that particular packet unless it is individually marked on your green card.
Tammy, can I just wanted to mention one thing. John typed a chat, which was a good reminder that folks also on your handouts on page 2, you have a lot of this information in a single document. So I just wanted to point that out as you go.
Okay, thank you, Millicent. Process and timeline. I laughed at this last night when I was looking at it because I have lost a couple of employees. The review and indexing takes about 20 weeks. It was at the time we first initially started this, and that's what I was saying earlier. Sometimes things change, but for those of you who don't know, Corey Hasty, last day with the division is December 21st. So we were 20 weeks behind indexing and reviewing cases from the date that we received it. I'm not sure how long that's going to hold out. We'll see. We have things on hold right now, but as it stands right now, it's 20 weeks. That is subject to change. Once indexed, once we approve it, the report to Vital Records, DSS 1815, will be sent to either North Carolina or out of state, depending on where the child was born. And also at the very same time, a congratulations letter is sent to the family, the adoptive family, explaining on how to get an amended birth certificate. I want to make sure that you let the family know if it goes out of state. Most states, South Carolina, California, New York are the three that come to mind right now, that they have a statutory fee requirement that has to be paid before they can amend the birth certificate. They will hold on to the report of Vital Records for about a year. If they don't get that fee to change or amend the birth certificate, they will literally throw away the report to Vital Records. Several years later, we'll get a call from adoptive parents who then need the amended birth certificate, and at that point we have to go back to the social worker to redo the report, send it back to the clerk, and it comes back to us. So please make sure to tell your families, particularly out of state, to go ahead and follow up and get that amended birth certificate. That is the only thing, let me see.
Tammy, don't forget to point out that in the handouts you've got a copy of each of those letters. I'd never seen those before, and I think they're really helpful.
Oh, that's true. We did send out a copy just so you could see what each one of those letters, congratulations letters, look like. And there's several there. Our goal at the division, DHHS, is quality control. Just to give you a little understanding, once we receive it, not only is it indexed, but we have to review it for statutory compliance and review it for any errors. Our number one goal is permanency for every child, including adult adoptees. and we communicate with the clerk if we see any issues at all. We will send the case back with a detailed letter explaining what the issues are, if there's a non-statutory compliance, or if there's some kind of error that needs to be corrected. It is up to the clerk to send it back to us with a statement. It's either they correct it, or if you want us to index it as it is, we just need a statement from you saying that to index it, and we will certainly do that. Vital records is different. They're independent from us, and they can decide whether to issue a birth certificate or not based on that. We've had several lately that we have received back to index as is, and we've sent it over to Vital Records for an issuance of an amended birth certificate, and they have not honored the report to Vital Records. So just bear that in mind. And I think we're ready for questions, Millicent.
All right, thanks, Tammy. Let me go through some of the questions that have come in. So one question is, I usually file an original and 5 copies of the petition, and this person has had 1 or 2 clerks say that they have to have multiple petitions, all with original signatures. So why would this be requested, and is it necessary?
No, it's not really necessary. I think the clerks used to send us an original petition before the statute changed in 1996, but now it's no longer required. The original petition has to be one for the file. I think Social Services or the private agency always wants an original of the petition, and then if there's an attorney or the prospective or adoptive parents probably would like an original. I still think signing 3 originals is a good thing. So the clerk will have one, the DSS or private agency will have one, and then the adoptive parents, I think, need to have one. But DHHS does not. We can just have a copy.
Okay, thanks, Tammy. Another question is about someone who actually adopted 3 children over a year ago and has never received a letter from Vital Records. What would you recommend for families that don't get?
Okay, the congratulations letter does not come from Vital Records. It comes from the Division of Social Services. And if you didn't receive it, you need to give us a call, and so we can check on it and find out. Maybe, I don't know if you've moved. So a lot of times the report to Vital Records has the most current address, but sometimes we get our letters back, someone's moved or the address that they submitted on the report is incorrect. So please give us a call if you've not gotten the congratulations letter or your families have not gotten the congratulations letter, and we can certainly look it up and either resend it but it does come from us, not Vital Records.
Thanks, Tammy. And here's a question. Why would a clerk require certified copies of monthly post-placement documentation in addition to the 1808?
That I have no idea. The report to, the report to the court should be the original, of course, and the report to the court comes to us along with all the other originals. But I do not know why they would want it certified, and I know that the clerk has to sign the report stating that they've reviewed it and seen it and recognized it as a document. But I have no idea about that and why the clerk would do that.
Sorry. Thank you. And someone asking for a more complete list of those states that will throw away those reports. I don't know if you have that or if that's something we can put in the Vital Records or in the follow-up document, or if it's simply a matter of you never know how long states are going to hold on to.
That's right.
So we will try to clarify that in the follow-up document. So another comment that's somewhat related is, why is there a lag between adoption assistance money starting and the foster care board checks ending? That this seems to be a recent recurrence over the past years where families are not getting the money that
you will need to contact Amelia Lance with the Division of Social Services. She handles all of those contracts, and she's responsible for the financial piece. I don't think I have Amelia's phone number on me, but I do know it's amelia.lance@dhhs.nc.gov. I also saw another question about, is there a fee that you can pay to expedite birth certificate at Vital Records in North Carolina? There is. It's $15. They will do it same day, I think, if you call and schedule an appointment with them, and it's a $15 expedited fee. If adoptive parents don't pay that expedited fee, I think they are about a 2-year lag behind us. So that's something your families might want to consider.
Okay, thank you, Tammy. I think those are all the questions specifically on the timeline. I know there's lots of other questions coming in about the process. I think we're going to be answering a number of these in the presentation, so I'm going to ask Jane if you would, is it Jane or sorry, let me just look. We're going to go on to our top 10 issues, and I will pass the mic.
Good morning, everyone. Yes, we want to start talking about the top 10 issues that we see coming into the state and how we need to avoid some of these problems. They just do a really good job with these PowerPoint things, and I just need to keep clicking so these cute boxes come up, and hopefully I won't completely mess this up. So, you know, obviously I'm old and not very techy, so we're going to give it our best shot here. But the first order of business is to remember that the absolute thing we have to have in every adoption is jurisdiction, and that's governed by 48-100, and that simply answers the question whether a petition can be filed anywhere in North Carolina. And as I hope all of you know, many other problems can be fixed, but this cannot. This is absolutely the kiss of death, and it voids any decree later issued. So we want to be sure that we get jurisdiction correct from the beginning. We want to contrast that with venue. Venue is, once North Carolina has jurisdiction, where should the petition be filed? In what county should the petition be filed? And in fact, lack of proper venue does not void the decree. In fact, years ago, prior to the 1996 rewrite, the venue statute listed the 3 counties that we'll talk about in just a second and said, but you can file anywhere else as long as no party objects. And that was simply in recognition of the regular rules in North Carolina for civil procedure that venue is something that can be more flexible. Getting back to jurisdiction, the classic requirement, as I'm sure most of you are aware, is that the petitioners have lived or been domiciled in North Carolina for at least 6 months immediately prior to the filing of the petition. Domicile, of course, is your legal residence as opposed to perhaps where you simply reside now. Some of the clerks have dealt with this issue where petitioners are in the military, they're missionaries, students, or simply working one place and living another, or domiciled in another place. So if they are claiming that their ability to file here is based on domicile, then you do need to make sure that in fact you believe that North Carolina is their permanent legal residence, even though they may presently be living somewhere else. But one of the things that we did change fairly recently is to expand the ability of out-of-state petitioners to file here. And they may file here if the child is in the custody of a county DSS, or that should also say licensed child placing agency. We came to realize that was necessary because we ran into problems with a child in the custody of DSS, let's say cleared on the basis of relinquishments, needing to be placed in another state with relatives or some other placement. I remember a heated discussion I had with a Texas attorney about this. And they said, well, we have a problem because no one can file a petition in Texas unless the child is cleared for adoption. And we see by your relinquishments that the child is not totally cleared by a relinquishment. It's not cleared till the final decree. And so we really ended up with that chicken and egg thing. And I will tell you that so many types of law are similar across the country. Adoption is not one of those. We have 50 states. We have no Uniform Adoption Act. Actually, we have a Uniform Adoption Act, but nobody's adopted it. So what we realized was, okay, fine. We will just say, as long as the child remains in the custody of a DSS or licensed child placing agency, we can finalize here. And that allowed for some of these adoptions to go forward that otherwise had been stymied. Also, we allowed for private independent adoptions to take place here as long as the child has resided in North Carolina for 6 months or from birth. That can be a day, 2 days, but they must file while the child is here. You see at the bottom that the DSS 1800, the adoption petition, has blocks for all these permissible options. I'm going to click forward 2 slides, and here's page 1 of the DSS 1800. So these are the 4 possible blocks. I remember getting a call from a clerk not too long ago saying, can they really file here? I know this is important. And I said, well, the first thing to look at is which block did they check on the DSS 1800? And she said, oh, they didn't check a block. I said, well, that's probably a good sign that in fact they didn't fall within one of those, and that in fact was the answer. So here's sort of the 4 possible options for jurisdiction, and I just want you to be aware of those and something that you need to take a look at. Going back to venue, venue has 3 options: the county where the petitioner lives or is domiciled, the county where the adoptee lives, often done again in these private out-of-state adoptions of newborns, and also for adult adoptions, and the county where the agency that placed the child has an office. As you well know, many of our adoptions, and this is a good thing, have 2 agencies involved: the agency that has custody of the child and the agency that found the home finding agency. The agency that placed the child in that situation, of course, is the agency that is clearing the child, the agency with custody that is clearing the child. That's what we're talking about there. But if an adoption is filed in another county, it can be dismissed or transferred at the discretion of the clerk. It is not mandatory that that happen. And I will tell you that some of the time, one particular instance in which it is really helpful for clerks to be flexible, and I've talked to a couple about being flexible in this situation with venue, is where out-of-state petitioners come in. The child is actually, is from County X, that is the birth mother lived in County X, but she went to County Y to have the child in the hospital. So the child was born in County Y, but they're now waiting in a hotel room in County Z for the ICPC clearance so they can return to their home, and so they've got to figure out where to file. And I have certainly talked in those situations to County Y and County Z about feeling like either one of those would be fine, even though they may not actually be in that county at this moment. So I think we do need some flexibility with those situations. Clicking past this again, just another reminder that because we do allow out-of-state petitioners more frequently now, you will be seeing the pre-placement assessments from their state. We have no form for pre-placement assessments anyway, so whether it comes from North Carolina or another state, you need to make sure it's meeting the requirements in 303. You will also see, however, that in these out-of-state petitioners, we need them to use that DSS 1808 for the report to court. Each block on that form captures very critical information for federal reporting and also our ability to draw down adoption incentive money. So we need to send the 1808 out to an authorized agency in that state, and hopefully in our agency adoptions, you'll have a lot of assistance from the agency here to the agency there in getting it filled out. In private adoptions, it can be a little trickier because the attorneys often are not very familiar with the 1808, but in any event, it needs to be used. And then we also made a recent change that we'll talk about at the end, allowing the use of background information forms from that state in lieu of our DSS 5102 and 5103 if they are substantive. I think I was going to try to say substantially, but anyway, equivalent. And again, the key is capturing the information, not using one particular form. I did see a question early on, and I do call myself the DSS 5102 and 5103 Nazi kind of, because I really do feel like clerks and agencies need to push harder and be more insistent about getting this information. If all she knows is that the dad's name was Kool-Aid, if she actually knows who he was. She can tell you basically how tall he was, what color eyes he had, what color hair he had, you know, his skin tone, anything they talked about that he was interested in besides her, etc. And I can't tell you how important that is, not only to the adoptive parents, but as the adoptive parent of daughters who are now 31 and 26, how important that is to adoptees as they get older. So yes, please do push for that information, whether it's on our form or on another form. Thanks. I think it's Tammy's turn.
It is, and for those of you who know me, we're going to talk about service to fathers by publication. This is a pet peeve of mine because we have so many times, so many issues that the reason why we have to send cases back is we don't clear all fathers. I know it's a tedious thing to do sometimes, and attorneys are kind of reluctant to do it also. But please remember, we must clear all named fathers, including putative, any kind of birth father, legal father. Legal fathers, even a child born within 280 days of a legal separation or divorce is considered a legal father that needs to be cleared. If whereabouts are unknown, before I get to that, I just want to say, make sure that you have an affidavit due diligence search. If you have a name for father or fathers, any kind of last known address, did they try to serve personally? Did they do diligence search? How did they try to search for the father? By internet, DMV searches. But if after all of that, no prevail, they still cannot find the whereabouts of the father, they can publish in the newspaper where he's believed to be. A lot of times when you can publish locally where the petition is filed, but I always have a question where that's concerned, because does a mother certainly most of the time knows where the child was conceived, so that's a good chance that that's probably where the father is. But that is one thing that takes a lot of time. The affidavit of due and diligent search we don't get on a number of occasions, but also when they publish, make sure that they're putting all the information in the publication that is required by statute. They can be served personally by certified mail, but this is strictly about publication.
Tammy, if I could chime in for just a second. Clerks out there, I know sometimes when you say, where's your due and diligent affidavit, you know, the attorneys kind of may look at you and say, well, I don't have to do that. Well, in fact, Rule 4 of the Rules of Civil Procedure requires that it happen in every single civil case. And if they were going over to the district court and terminating parental rights on this father, they would have to submit an affidavit warranting the use of publication, meaning I've looked for this guy like I want his kidney. I can't find him. I don't have any reliable information where he is, or maybe I have this reliable information, so I'm going to publish there. They've got to do that for judges in TPRs or in any other civil case. So they've got to do it for you if they are trying to simply give notice under 482401 and clear him in the adoption. And that really is what you want. They need to look for him like they want to actually find him, and that's what you need to see. And in fact, DSS attorneys are aware that, you know, we've got a couple of examples of diligent effort checklists floating around, and if it would be helpful, we could include some of those in the Q&A document just to give clerks examples of where people need to look so that you will feel more comfortable with it.
And is it okay for me to chime in just real quick? The question was just asked, is publication ever successful? And I can definitely tell you that yes, it is.
Yes, I second that.
And I third that. I have had a number of them find me in cases that I was involved with by publication. But again, a lot of it comes down to, can they identify themselves in that publication, as Tammy just said. Some of you know my favorite father is Kool-Aid, and it's a real case where he was known as Kool-Aid, but that notice was very detailed. Father named as Kool-Aid, mother known to you as Candy, child conceived in a Ford F-150 pickup, parking lot of, of a certain nightclub in Myrtle Beach. So that's the kind of detail that we need so people, in fact, see it.
And I can tell you that I had one case several years ago that the father was from Florida, and the mother said she didn't know who he was when she did. She was about to marry him. They at least did the publication in Florida. He had been in the same place, his family was there, and a family member actually saw the publication and brought it to his attention. He ended up getting his daughter. So it does happen, and this is the reason why you're supposed to do it. Moving on to unknown fathers in independent adoptions, it's exactly what Jane just said. That's another thing. When publication is to an unknown father, sometimes we just have a blurb in there. Your rights are going to be terminated, you unknown father, and this is the date it's going to be terminated. Well, there's no man that's going to be looking at that's going to clue them in that they are the father of this child. So they need to be specific and give, even if it's a first name of the lady, her height, blonde hair, blue eyes, we met at Gillies, they need to be specific enough that they know by looking at that they have the chance of being the father of this child. Guidance on publication and content in private adoptions must state that the rights of the father will be terminated upon entry of the adoption decree if no response is given. Of course, if you have a response, whether a father served personally or by publication, you of course have to have a hearing to decide whether his consent is required. But if he doesn't file an answer, if a father does not respond, the clerk will enter an order that consent is not needed, and final decree will terminate rights.
Tammy, I see a question. Does the attorney file the affidavit prior to publishing? I think Rule 4 basically says it's got to be filed showing that publication is warranted. When I was doing TPRs for county DSSs years ago, I always filed it in advance. I wanted to make sure the judge agreed with me that publication was okay. Clerks, you're the judge. So yes, you should absolutely be asking for this in advance of publication. And again, also not only the circumstances warranted publication, but why they're choosing the particular newspaper that they're choosing.
And then moving on to agency adoptions, rights of the parents are terminated in juvenile district court. But if the father doesn't respond, judges terminate rights after hearing. But please be careful with this. You're still reviewing, even if a district court judge has signed a termination of parental rights. You as the judge, the clerk under the adoptions, you have to also look at that TPR to make sure it's correct. Judges make mistakes too. County attorneys make mistakes. There have been times that we've got a TPR on 3 children, but it's not the one listed. There may be 4 children. They did a TPR for 3 at a separate time than they did another child. And the adoption that we're reviewing, it's terminated all the other children's parental rights except this particular child. So just be careful with that and go behind even the TPRs, the termination of parental rights, the judge's son, just to make sure they're accurate and correct and that they actually terminated rights.
Okay, it's my turn if I can get to the right slide. Here we go. Service of notice to non-parents. We were just talking about giving notice to folks. Now remember, we're talking about all different kinds of adoptions here. So DSS, you obviously are focused on terminating the rights of anybody who could be a parent, mom, dad, legal dad, putative dad, unless you have a court order with a judicial finding that someone is not a father. That's a possibility. Sometimes DSS will list a couple of possible fathers on a petition, or somebody will parachute in, say, I think I'm the dad, there's some DNA, there's a hearing, the dads are present, and the judge finds that A isn't, or B is, and that certainly helps us out a lot. But obviously, agencies are going to go down the TPR road, whereas in the private adoptions, rarely are they going to go over and do a TPR these days, because it is easier and simpler and cheaper to give notice under 482401 and clear the parent that way if it's possible. But we also give notice to some non-parents, and this certainly affects all of us out there doing all types of adoptions. The first notice that we often run into is notice to the husband of the petitioner if the petitioner is requesting waiver of joinder under the statute that you see there. I know I have heard from many a DSS, a foster care worker or adoptions worker where a foster mother wanted to adopt, has always said she was divorced, but now that it's time for the adoption, we're asking for the divorce decree, and lo and behold, there is no divorce decree. She wished she was divorced. She hoped she was divorced. Somebody said she was divorced. It's been so long. Surely she's divorced, but in fact, there's no divorce decree. So we're talking about a waiver. However, in those situations, of course, the husband is usually not around. She may not even know where he is in that situation. But you can also request a waiver of a, and we're talking a spouse, but normally a husband, even when the spouse is actually going to remain in the home. The example that usually comes to mind is the adoption by a grandmother. Her husband is the step-grandfather, loves the kids, happy to raise the kids, but doesn't want to adopt the children. So again, as long as the clerk feels like it's a good home situation with him there as a parent figure, it is fine to go ahead and request waiver of joinder of him, even though he is in the home. The clerk, as you know, can, in those situations, give notice. This is a situation where that notice can also be waived. So if the foster mother says, oh, Lord, guess what? I really am still married. I haven't seen this guy in 10 years. What in the world is the purpose of publishing and giving him notice? So that would be a situation where somebody would probably request waiver of that notice. Also, we need to give notice to a child 12 or older if the petitioner is requesting waiver of the child's consent. Again, that is generally limited to situations where the child, because of a mental or physical disability, is unable to give consent, or perhaps doesn't want to be responsible for giving consent, feels very conflicted about actually signing it, feels disloyal but wants to be adopted, and is happy with that waiver. I know some of you have run into step-parent adoptions where you go out, the child is 12 or older and has never been told that this is her stepfather, and they, want to do this kind of waiver. And in my personal opinion, that is not what this waiver has ever been meant to cover. And then finally, any person with custody or a right to visit or communicate with the child under an existing court order, not somebody who would like to go to court and get an order, but one who already has it. DSS, pay attention to this, because a lot of us, we go through a long battle in juvenile court before we get to adoption. And let's say we've got a grandparent or other relative who has really wanted to be the placement of the child, but in the end, let's say foster parents are going to be adopting. However, at some point along the line, an order was entered in juvenile court saying grandmother has the right to visit every other weekend, or grandmother can call every Sunday afternoon. If that order is still in existence when the adoption petition is filed, she is going to have to get notice of that adoption petition, which may not be the answer that you want. And if she gets notice, what rights does she have? Anyone whose consent is not required, i.e. a non-parent, first of all, they can waive it in writing. So if you've got that step-grandfather in the home, you don't even have to actually give him notice. He can waive in writing getting that notice. But he could also turn around, and obviously I don't think you would, but let's say you give notice to that grandmother who still has the right to communicate every Sunday afternoon, and she can ask for a hearing about whether the adoption is in the child's best interest. That, of course, is full of issues of fact, clerks, so you would be transferring that to district court under 48-601A1.
And timing of pre-placement assessments, this is another scary scenario. It usually happens in independent adoptions, or only independent, usually when direct consent's been given. But if a pre-placement assessment is required, not given to placing parent prior to placement of the child, revocation is open and extended until they are served with that pre-placement assessment, and then the placing parent is given 5 additional business days to revoke their consent. And I just be really careful with this, because how you know that they've been served with it is the 5219, the DSS 5219, which is the petitioner must file, that's showing proof of receipt that they have submitted this pre-placement assessment to the placing parent. It can be served personally or by certified mail, but one example I want to give with this is I had an attorney one time that didn't have the pre-placement assessment. The placing mother signed the consent, and I went ahead and filed the petition because you don't have to have that pre-placement assessment to file it, but I kept telling him we needed that. 6 months went by and she came in and revoked her consent, and she had every right to do that. If you file a petition like I did that time and you don't have the pre-placement assessment, you cannot order the report to be done. You have to wait till that pre-placement assessment is filed with the clerk of court. Once it's filed, you have to wait 30 days to order the report, the DS 1807.
Tammy, I think you mentioned something that's not really on the top 10, but is incredibly important, and we're going to say it again, and I want to emphasize it, and that is when someone comes to the clerk's office and wants to file the petition, you take the paper, you clock it in, you stamp it, it's done, it's started. There is no, although all clerks are the judges of adoption, no judge can prevent anyone from filing something. I can file a piece of paper that says Jane versus God and the filing fee, and you clock it in. So my top 10 rules for clerks, and which I think I've now is like the dirty dozen rules for clerks, but the first one is take the paper. So certainly, however, as Tammy pointed out, you may take the paper and then say, well, it's obviously not complete. We've got a lot of other things that have to come in before we can finalize. Taking the paper and filing it certainly doesn't mean you're going to finalize. But these late PPAs are not going to happen in agency adoptions because DSS cannot place without an approved pre-placement assessment, but happen a lot in private adoptions where everybody meets and greets and for some reason aren't aware of the pre-placement requirement and then are scrambling to get it done, usually through a private agency. But I've had examples like Tammy just mentioned where they can revoke up to and including 5 business days after they get it. So these adoptions are quite at risk until these
And I just want to say that's the reason it's so important to get the correct mailing address on the consent or the relinquishment, because sometimes even in agency adoptions, we have to go back and give a 10-day notice to parents. I just want to interject here that it's so important to get an address where you know that you can serve whether a 10-day notice through an agency or the pre-placement assessment in an independent, a place where you know that they're going to be able to receive mail, certified mail, and that you can show proof that they received it. And I think we are at question time again.
Okay, thank you all for typing in the questions. We have so many on this, so we are going to, just a reminder, we're going to go through them and we're going to take about 5 minutes and answer as many questions as we can. Do not fear if your question does not get answered in the webinar. We will still try to include it on the follow-up document. So I'm going to zip through some of these. We have an order for report, and in the process of completing, realize the family is second cousin and needs a PPA. Does the family need to file anything like an extension while they get this? They are representing themselves. I'm looking at our
we're supposed to be finishing adoptions in a presumed minimum of 90 days and in a presumed maximum of 6 months, but as we're going to talk later, both of those can be shortened. One can be shortened, the other can be lengthened. So if it's going to take more than 6 months, yes, you should address this with the clerk and ask for it to go out beyond that. That really shouldn't be an issue. I've had some interesting discussions about second cousins versus first cousins once removed, which sounds very Southern, but in fact is actually second cousins are on the same generational level with each other as our first cousins, but if a first cousin adopts her first cousin's child, it's actually the first cousin once removed, and I've just told clerks if they want to call that first cousin, I won't argue with them, but yes, true second cousins would need a PPA.
Okay, thank you. And sorry, let me just scroll down to the next one. Jurisdiction. Can an attorney file an adoption petition for a child who is involved in an open family court case
That's an excellent question. If you look at 48-100, which is that jurisdiction statute, I didn't discuss that, but C talks about something called the Uniform Child Custody Jurisdiction and Enforcement Act, the UCCJEA, which is found in Chapter 50A of our statutes and has been adopted by all 50 states. And what it basically says is one state at a time deals with the custody of children. It actually, the UCCJEA on its face does not apply to adoptions, but we make it apply to adoptions, as do almost all other states. So in a situation like that, you would be looking for the affidavit on status of minor child. That's an AOC form, which I don't remember the number right off the top of my head, but that's an AOC form that talks about where the child's lived for the past 5 years and are there any outstanding custody orders involving it. 48-100 does allow the filing of the petition. Again, we can always file the petition. And then it allows 60 days for the petitioner to clear up the UCCJEA problem. That is, to go back to the original state and say, do you still have original jurisdiction? You know, will you cede that? Does North Carolina have the ability to modify? Those are definitely attorney questions, but there is a 60-day window in which to get that fixed.
Okay, thank you. And John McMahon, and I'm so sorry I didn't introduce John and Philip, but John McMahon is furiously taking notes so that we can get these answers out to you, including the ones that you heard but might not have gotten all of it. Okay, should a clerk keep an adoption in her county merely for the convenience of an attorney who asks the petitioners live in another county? I think I know the answer to this, but...
Well, DSS should always keep copies of their adoption in their records. They have to permanently retain them, and of course we permanently retain at the division, but it's only the county that's involved. If you might have one county that placed and another county that did post-placement, then both counties would keep all of their records. But if there's no county, if there's a county that they're not involved at all in this, they should not be keeping copies. They should not have it in their records. It's only the county placing and the county following up that permanently have to retain their records.
I do think sometimes it comes up in just a private adoption where an attorney is practicing in a bigger county and the petitioner actually lives in a nearby smaller county, and the attorney, just for the convenience, would like to file it in the bigger county where they operate a lot. I mean, again, venue is not the kiss of death, but I think most clerks are you know, want to focus on the 3 venue options, and unless there's a really good reason to not use one of those, would usually, in your discretion, require that it either be transferred or dismissed and refiled in the appropriate venue county. Again, if you choose not to do that, it is not going to be, you know, a legal problem for the adoption. But I think most clerks are not, generally don't do that simply and only for the convenience of an attorney.
Thank you. I'm going to get in a few more. Do you, if a potential father is identified, if a potential father is identified but signs a denial of paternity and won't submit to DNA, does he still need to be cleared by the court, or is the denial sufficient?
Actually, signing our denial of paternity form does in fact clear that father. So if you take a look at 48-2401 C3, which talks about what dads need to have notice, if he denies paternity, he does not get notice in the adoption. But of course, that raises the issue of if he is not, who is? So most of the time, folks do require a TPR or notice in an agency adoption or notice in a private adoption to an unknown father, just to clear the decks on all the dads.
And I just want to add, only a biological father, not a legal father, can sign the denial. A legal father cannot sign a denial of paternity because by statute he's the legal father and needs to be cleared.
Right, that's a really good point. So if he's married to mom, he can't, it's that good old common law presumption that you're the father, and he can't deny paternity. But an unwed dad is whom we're usually talking about, but that's a really good point to keep.
And I just want to throw out there, and Jane and Tammy, correct me if this has changed. I know when I was reviewing adoptions, we would often get just a DNA test without a judicial order, and that is not sufficient clearance or acknowledgement of paternity, there has to be an accompanying judicial order with that
And
test.
that's correct. In fact, it just happened last week. We got a case where we just had DNA testing and no judicial determination on that, and that does not clear a father. We have to have the judicial determination.
Yes, it's 483603A2 talks about if there's a judicial finding that X is not the father, or Y is the father, you know, one way or the other. You don't have to worry about X. And in addition, not only do you need a judicial finding, but there's an issue about whether or not X and Y were even parties to that action. So, you know, if there's a finding that X isn't the father, but he wasn't even a party to that action in which the judicial finding was made, then I think that raises other issues as well. So it's usually better to go ahead and affect service or terminate rights in those situations.
Okay, I know we have more questions. I'm going to have us go on. There's a number of questions on PPAs, but we're going to talk a little bit more about those in the next section, so we'll try to catch those questions in the next section.
It's okay. We had a little snafu there. Okay, I'm going to take this one. Okay, so we're not perfect. What can I say? All right. What happens when you get unfavorable pre-placements and reports in independent adoptions? Again, I don't think you're going to get many unfavorable pre-placement assessments. That obviously is a huge problem, but it's not terribly unusual to get unfavorable reports in some independent adoptions, specifically relatives and step-parent, or the phone calls I get. I think it's important to recognize that the clerk is not bound by the agency's determination in either of those. However, you must consider them in determining best interest. Now, again, obviously in agencies, you got to have a favorable or we're not going forward. But let's say you've got a step-parent adoption and DSS does an unfavorable report. Sometimes what I have found is that there's confusion at DSS. They are looking at the fact that the stepfather has a DUI conviction 3 years ago. If he were trying to adopt from foster care, that would be a bar. But that requirement, that fingerprint check criminal history requirement under 483309 does not apply in your basic step or relative adoptions. Yes, we do a regular criminal record check, but everything is really on the table and in the discretion. So sometimes I think the unfavorable report may be based on a misapprehension of what the standard is. But in any event, I think it is really important that if either of them, see, there you go, there's a little box. If either of them is unfavorable, the clerk should hold a hearing to determine best interest. It is true that when you just sign the decree, it makes a finding of best interest, but here Tammy would get it. It would say a boilerplate, it's in the best interest of the child to be adopted, with an unfavorable report to court. So we really want you to hold a hearing, resolve it. Of course, under 482604, you have to give notice to folks. The agency is there to explain why they wanted to be unfavorable. Yes, DSS, you have to be present and talk about why you did that in your 1808. And the petitioners are there to say, you know, why it's okay and they're good people, etc. So yes, if you'll take care of that, I think that will make us feel a lot better. Yes. I'm sorry. Yes, that could be considered a suitability hearing. And also, you know, one thing I bookmarked in my statute here is on the report to court, it talks about it must include any fact or circumstance known to the agency that raises a specific concern about whether the proposed adoption is contrary to the best interest of the adoptee because it poses a significant risk of harm to the well-being of the adoptee. So if you're out there doing an 1808 and you're not recommending it, you know, you need to be paying attention to what the standard is in the statute for your, you know, supporting lack of recommendation. All right.
It, and I threw Jane under the bus. That was actually mine. I had her name on it. We're used to this, though. But I just wanted to add, if you ever have DSS or private agency, an unfavorable pre-placement assessment, they do need to be filed with us at DHHS. We do have a data system that we keep all those in. So if you ever have one, please submit them to us and so we can have them on file. The next thing we're going to talk about is inconsistent names in the files. Again, we just had some of these last week. 4 documents that must match and have the full legal name of child and the adoptive parents. And that is in the petition, the report to the court, the final decree, and the report to vital records. And just please be consistent. Make sure it's the legal name, and make sure that it's the same and consistent on all those forms. We just had one last week where a grandfather was adopting, and it was imperative that he get his child on health insurance. And when we reviewed the adoption, the only thing wrong with it was the final decree missed his middle name, but his middle name was on all the other documents. So we had to call the court and get an amended decree, and it held up the adoption for a few days. So make sure, sometimes these small tedious things are the most important, and that it can hold up an adoption. It also, the inconsistencies will prevent issuance of the amended birth certificate. And ever since 9/11, used to, you could take the final decree to Social Security, get a passport. That is no longer true. You have to have that amended birth certificate for everything. So when a child starts school, getting their permit, they're going out of the country, you can imagine our phones ringing off the hook constantly needing that amended birth certificate. And then when we review it and there's something that's missing that we know can't go forward, that's a delay in getting it done. Once the decree is issued, please remember any name change that follows that decree must be under Chapter 101 in Special Proceedings, a legal name change. Once that final decree is issued and sent to us, the only way they can change that name at that point is to do a legal name change in Special Proceedings. That does happen frequently. For some reason, a month later, they decide they want Jessica instead of Sarah, and they have to go through Special Proceedings and do a legal name change at that point.
Okay, let's talk about some foreign adoptions, because they certainly come to the clerk's attention and they absolutely can be confusing. There are at least 3 types of foreign adoptions. The first one is what I'd call the classic foreign readoption. This is a child that's already fully and finally adopted abroad, and the parent wants to readopt here. They will come in, and of course they will file the petition, and they will have the original birth certificate and adoption decree from the foreign country. Those are the only ones they have, and they're not getting any more. If they are lost, if they are destroyed, whatever, they're really out of luck. So they will really appreciate it if you will make a copy of those, certify that copy as exact, and send those certified copies to Tammy's office and allow them to have the original birth certificate and adoption decree back. It is not, as I said, that is just really an issue that is a problem for some of these petitioners. Now, keep in mind that you do need a pre-placement assessment for these adoptions. However, you will simply use the pre-placement assessment that was created for the adoption. The adoption might have taken place 10 years ago, and they're just now getting around to readopting. And that's fine. Use the pre-placement assessment that was valid when that child was placed for adoption, and you get your current information by requiring a report to the court now. I have had a couple of situations, and I'm talking just 2 or 3, where children were fully and finally adopted abroad without a pre-placement taking place. And those were in some odd countries. The one that I remember the most was Mongolia. And this was a missionary who was in Mongolia and wanted to adopt a deaf 4-year-old street child. And I think the Mongolian authorities said, you want to adopt a deaf, homeless, 4-year-old child? Here you go. Here's your adoption decree. Go with God, or whatever. And he comes back here. He wants to have a cochlear implant for the child, and there's no PPA, no pre-placement assessment was ever done. So he actually had to do one now in order to readopt. And of course that was a financial burden for the family, but very unusual. And then I've had two one from Thailand, where they actually allowed, again, missionaries to adopt in Thailand because they were there for a long period of time, but no pre-placement assessment. And then one country in Africa. But almost always you will have pre-placement assessments that were done.
And Jane, can I add something? I'm sorry. I'd like to add something at this point before we move into the guardianship ones, and that is, some parents don't have to readopt. If they have a final decree from the foreign country, they can submit their foreign documents to Vital Records and get an issuance of the certificate of identification. A lot of adoptive parents want to have it on record here and have a final decree from this country, but I'm finding a lot of agencies or clerks are not informing them, or they don't know. It's after the fact that they realize that they could have just submitted their foreign documents to Vital Records and gotten their certificate of identification. And I think some parents would have chosen to do that instead of readopting. It's kind of half and half. Half want to have that final decree here, and half would have just had rather gone to Vital Records and just gotten the issuance of certificate of identification, which is really what they're after anyway. So I just wanted to add.
The statute that applies there is 130A-108, and basically it allows two options for these folks. And as Tammy said, the first one is simply to get a birth certificate, which is the certificate of identification. And they can simply get that and have that and know that that can always be replaced because they've got a North Carolina version. However, the name on that will be exactly the name that is on those foreign documents, but that's fine, and they can absolutely do that. However, if they want a North Carolina adoption decree that they can also get a replacement of, then they can use 130A-108. A is just getting the birth certificate, the certificate of identification. 130A-108B is filing to readopt, and in that case you get both the birth certificate, the certificate of identification, and a North Carolina final decree of adoption. But you're right, a lot of people are more interested in the birth certificate. As an adoptive parent, I can't remember the last time I needed to show somebody my adoption decree, but we need to show birth certificates for children a lot. Okay, as we talk further about foreign adoptions, we talk about guardianship. These are the adoptions where there is no full and final adoption abroad, but the adoptive parent had the pre-placement assessment, traveled to that country, and was given guardianship in that country with the intent for them to return to the U.S. with the children or child, and then after a period of supervision by a U.S. agency to file a North Carolina adoption. So the adoption being filed in these cases is the only adoption being filed for these children. Normally, the agency that is doing those supervised post-placement visits is also the agency that is authorized by the country to consent when it's time to do the North Carolina adoption, but that's not always the case. Sometimes these folks come back as guardians of the children and end up actually having to consent to their own adoption because there is no agency authorized. Again, countries do things differently, but the guardianship does clear the biological parents in the foreign country, so no consents are needed. And again, they would have had a pre-placement assessment when they did this, and now what we're looking at is getting the current 1808. I will say in these cases that almost always they have to adopt here and then apply for citizenship. In those adoptions where it's full and final abroad, normally the child is automatically a citizen under the Child Citizenship Act of 2000 when he enters the country. With guardianship, they normally have to apply for citizenship after they finally do the North Carolina, the U.S. adoption. And CIS, Citizenship and Immigration Services, will need a copy of that 1815, the report to vital records, that connects the name of the child as they came in on the visa with the name of the child on the final decree. So we've got some information, clerks, on your intranet about some samples about getting folks that information. And then finally, we have adoption of a foreign-born child, meaning the child was born abroad, is now in this country in some way, form, or fashion on some sort of visa. There's been no adoption, no guardianship in the foreign country. This is treated as any other independent adoption. You do need the consent of birth parents or other clearance in that situation. And our DSS 1802 have traveled around the world. They have gone to a lot of places and been executed in other countries. Do keep in mind that 483605E does provide that a consent or relinquishment is valid if signed in accordance with the procedures of another state or country. Again, we're talking about the formalities, and the formality that might be missing in a foreign country may well be the notary. That's just something that a lot of countries won't have. We generally try to involve some agency or attorney and at least have witnesses in those situations.
And in some of those cases, they have to be signed by a judge or a magistrate. They at least have a judge or magistrate that can sign those forms. And also, I just wanted to add with the foreign, we have a lot of relative adoptions that are from a child that's born in a foreign country. Same thing, it's treated as a relative adoption, even if that child is born in another country. Moving on to incorrect forms, just be aware of attorney drafted forms. They can file them. There's nothing to prevent that, but they must meet Chapter 48 requirements, which puts a little bit more work on you to review and peruse their made forms, attorney-made forms, to make sure that it has all those requirements. And please remember there are different forms for step-parent and adult adoptions. The one question I get asked more than any other on a step-parent adoption, when it's the biological father who's signing his rights away, if they sign an 1802, what's the problem with that? Because it does the same thing. But on the step-parent form that he will sign when he's not the spouse of the step-parent, is it addresses past due child support payments, and it also addresses that his rights will be terminated, but he understands the biological mother's rights will not be terminated. So it's very important to make sure that you use those separate forms, or that they are used. There is no form for pre-placement assessments. However, they must meet the requirements of 483303, which sets out what is required in a pre-placement assessment. Please make sure you use the checklist to ensure you have all the correct forms and that you have all the information that is required. I think the checklist is on the AOC website. I know we also have the legal aspects of adoption manuals. We usually distribute those when we train, but we certainly will send them out to anyone who needs one. I think we just updated them the last time about 1.5 years, 2 years ago. And then we're going to move on to waivers. There are so many things that you can waive in an adoption that's under Chapter 48. They have many requirements. All should be in writing, and all are included in the adoption record. We have some examples in the manual of waivers, and you clerks always have a reason for the waiver. Usually it's at the request end, why they're requesting a waiver. If it's not in the request, make sure you put it in the waiver of why it's being waived. And the one thing that's recently changed is the 30-day waiver from placement. Clerk can extend time to file 482302A, but that's for petitions filed on or after October 1st. This is no longer required and no longer will be addressed by the clerk. But for all those petitions that were filed before October 1st, if they did not file it within the 30 days of placement, you need a waiver of waiving that right. A lot of people ask me, what's the placement date? And that's always on paragraph 6 of the petition. Usually in independent adoptions or relative adoptions, it's the day that the primary caregiver or primary parent signed the consent, transferring legal and physical custody. Then they should have filed their petition for adoption within 30 days. But like I said, after October 1st and any file that's after that, that's no longer going to be required. Waiver of notice to birth parents of adoptee and adult adoptions. This is one of the most common errors that we find in adult adoptions is adult children are not served, or we don't have a waiver of service. Please make sure that the petition, any adult children must be served with a 30-day notice. Or, as Jane said before, they can sign a waiver of notice, which means that they no longer are required to be served the 30 days. If you do, or if they are served the 30-day notice, we just need the green card, the certified mail, along with an affidavit of service attached to it. Or the adoptive parents or spouse of the adoptee also must be served. There is a waiver requirement, 6 months for step-parent adoption. They have to be married for at least 6 months, or the child has resided with them for at least 6 months. If it's been a shorter period of time and they request a waiver, put your reason why. I think most of the time is military, when they're getting ready to go abroad, or if they've lived together for a very long time before they got married. But be careful with that. We have a lot of calls from men that are now, they've adopted their stepchild. They are now divorced, and they call us frequently wanting to undo their adoption. So that 6 months requirement was there for a reason, and it is good. Just be careful when you waive it and for what reason you're waiving it for. You can also report to the court if the step-parent and birth parent have been married for at least 2 years and the child has resided with them during that time. Unless the child's consent is to be waived, a child has revoked consent, or both parents are deceased. Be aware, and step-parents can adopt even if the birth parent that they were married to is deceased, if they have primary care of the child. And I want to let you know right here too, if you decide to waive that requirement, if they've been married for more than 2 years, please bear in mind, clerks, that you're sort of doing a little bit of investigation for where the social worker would be doing it. You need to verify their marriage, so you need a copy of the marriage certificate, a copy of the child's birth certificate, and to do a local criminal record check, because what you're doing is you're finding best interest of the child, so you have to have some kind of evidence that this is the best interest. I had one time where the couple filed, it was a step-parent adoption, and I was ready to enter the final decree, and 6 months later I kept calling them, and I found out that I needed a copy of their marriage certificate, and they were never married. So that's why you have to have this documentation. It's your evidence and your proof that this adoption should be finalized.
Okay, let's talk about waiver of placement requirement. Tammy just mentioned it, and it can be a little confusing. Paragraph 6 of the petition asks for the date the child was placed, quote, for adoption, not placed for foster care, not placed for any other reason, but placed for adoption. In agency adoptions, placement for adoption can occur when an agency with custody has, cleared the child by relinquishment or TPR. And as most of you know, you generally have your adoption committee meet, make a decision, and then that is the date of placement. The child may not move, of course. The child may be, being adopted by foster parents, but that is the adoption placement date. In independent adoptions, it gets a lot trickier. The classic placement date is the date that the custodial parent consented. There's a difference between consenting and placing. If you look at 48.3.201, the parent with custody places by consenting. So you need a custodial parent and you need a consent. And so as you can imagine, there are a number of independent adoptions where those two things do not come together. And those should be situations where in paragraph 6, they're simply saying, see below to 12 or 13, where you can have those lines and put in other issues. We are requesting a waiver of the placement requirement. Because there is no consenting custodial parent. A couple of examples come to mind real quickly. Let's say grandparents have already gone to Chapter 50 court and gotten custody of a child because they proved mom was unfit or she consented for whatever reason, and now they'd like to adopt. Mom is okay with their adopting. She consents. She does not have custody anymore, so she is not placing. That would be a situation where placement would need to be waived. No big deal. It's just the child is not actually being placed for adoption. We simply have a consenting mom and some sort of clearance on dad who also doesn't have custody. Or you may have a child that was left with grandmother. Mom, will you take care of my child for a while? And now it's been 6 months. And mom's whereabouts are unknown, and the dad was never known. And she's talking to an attorney, and the attorney says, well, maybe we should go for custody. And she says, well, how about something more permanent? I'm really concerned. Well, how about adoption? And in that situation, mom has custody, but she's gone, and she's not consenting. So again, you would not have a child being placed for adoption. It's not a big deal in the sense that there are situations where you don't have placement, you don't have consent and custody, but when those happen, we want the clerk to take a look at it and allow the adoption to go forward anyway. Then the next waiver that I want to talk about is the waiver of 90 days between the filing of the petition and the decree. There is a waiver there is a requirement that 90 days elapse between the filing of the petition and the issuance of a decree. Remember, as I've already said, there's no minimum or maximum time in which to complete an adoption. I think it's important, if you're asked to waive that 90 days, i.e. to shorten it, that we talk very briefly about the primary purposes for that. The first is that we sometimes in many adoptions need required notice with 30 or 40 days to respond, depending on whether it's personal notice or publication notice. And then an agency has 60 days for the report to court. So when I happened to be sitting on the drafting committee rewriting Chapter 48 back in 1996, our thoughts were, okay, that's easily going to eat up 90 days between those two things, especially in your independent adoptions. And you also need a sufficient placement time to determine best interest. So if the child's been there less than 90 days, it may be difficult for the clerk to feel like she's got enough information to, to feel like there's best interest. However, imagine what happens when you have an agency adoption, a DSS adoption. They don't have anybody to give notice to. They've terminated. There's no one to give notice to. They can do their report half the time. They give you the report to court. When they give you, as soon as the petitioner files the petition and you let DSS know it's in comes their report to court. So they're certainly not taking 60 days to do it. And the child has already been placed there as a foster child for 6 months, a year, 2 years ahead of filing the petition. So there's certainly sufficient placement time. I would draw your attention to a waiver of the 90-day requirement. It is a handout, and it summarizes what I just said, but also points out that the final decree is an emotional as well as legal claiming process, and unnecessary delays really do hurt children who are waiting for the other shoe to drop. Everybody's promising them they're going to get adopted, but foster children learn really early on that there are a bunch of unknown adults out there, and judges and courts and meetings and hearings that take place that can affect their life. So the faster we can get some of these adoptions gets done for these children, the better off that they will be. So that handout is there for your assistance. I think we're going to talk about some questions, and Millicent's going to talk a little bit about the legislative changes. Actually, what we're going to do about that.
Exactly. You don't want me to talk about the legislative changes. So yes, we have, our presenters have agreed we are going to provide more written details about the legislative changes in the follow-up document so that we can use our remaining time to go through some of your remaining questions. So I am going to start back here. We're going to go through some of the ones from these last items. Let's see. What should we do in the case of twins? The paperwork got switched regarding the name that got attached to the wrong child. A number of questions about if there are typos or mistakes, what the process is, Tammy.
It depends on what document it's on. If it's a petition, an amended petition would have to be done. If it's on the report to the court, an amended report by the social worker, decree of adoption, you can amend that decree of adoption to correct whatever information is in there. The only one that we don't have as much control of as DSS and the clerks is the petition, which has to be amended and signed by the petitioner, and the consents. If there is an error on the consents that the parents sign, birth parents or relinquishment, when you amend that, they have to of course they have to sign that. It's not something we can touch. So it just depends on the document, but there are certainly ways to correct anything with any of these documents to just to amend them.
Okay, thank you, Tammy. Okay, another question is, it says, please talk about the 1808. I've been asked by the clerk to do 1808 and step-parent adoptions where the parents have not been married a year. When I meet with a family, the biological dad's rights have not been relinquished or terminated. Do you still do the 1808 and send in with the missing information?
No. You have to wait to, that 1808 is to verify and complete that information. What happens in these circumstances, if it goes on for a very long time, you're supposed to get your report in within 60 days to the clerk of court. If you can't complete that report within 60 days, which having that father's rights terminated is part of that, you either have to ask the clerk for an extension, and you might want to do that once, you might want to even do it twice, but sometimes it comes to the point where you have to send in a statement saying that you cannot approve the report to the court or complete it because of this reason, clearance of a biological father. It's at that point that it's up to the clerk to decide whether or not they would like to do a 5-day notice of dismissal. I do know that that has happened when cases have lingered, and it really sets a fire under the petitioners or the petitioner's attorney to get their attention that I need to follow up and get this done. So you do have options. You have 60 days to get your reporting in. If you can't get it in, you need to ask for an extension. If you don't want to do that, you can certainly just submit stating that you're unable to do the post-placement or approve because you don't have the documentation that you need.
Thank you. Do we have to have people sign their first, middle, maiden, and last names on all documents?
Yes, whatever their legal name is exactly how they need to sign it on all legal documents.
If an adoptive parent pays the expedited fee to Vital Records to get the amended birth certificate, how long does it take to receive that expedited?
Call Vital Records and make an appointment. You now have to make an appointment for them if you're going to pick it up. I know they can do it the same day. If they're going to mail it to you, it usually goes out the next day.
Thank you. If a pre-adoptive parent has been separated for 7 to 8 years and we are unable to locate the spouse, can the clerk issue a waiver of notice for that spouse?
Yes, yes. Absolutely. I mean, again, the question is, the law simply says if you're married, your spouse must join in the petition. If you don't want your spouse to join in the petition, then you make a request for a waiver, and obviously the fact that you haven't lived together, he's not in the child's life, in your life, would be a reason to go ahead and waive that. I also, talking about waivers, I see Teresa McGraw's asked, may we provide the waiver of 90-day My handout to clerks? Absolutely. In fact, one almost identical to it is on the clerk's intranet. So this is not a secret. I've said these things for years, and I certainly don't have a problem with your sharing it with the clerk.
And I just wanted to follow up about the waiver. That happens a lot in agencies, agency adoptions, where the adoptive mother is married, and sometimes it just comes down to not having the money to file for a divorce. So DSS frequently asks for those waivers of the spouse joining in.
Okay. A question regarding foreign adoption decrees. Does that apply to situations before the U.S. adopted the Hague Convention or Treaty?
Yes, it applies. It applies to any adoptions. Even before the Hague, it was very, very rare for there not to be, pre-placement assessments and all of those things in those. But yes, either way, Hague has standardized foreign adoptions, but not all countries, even to this day, are members of the Hague Convention. So that is still okay.
Thank you. Again, I'm sorry, I know there are lots of questions we just did not have time for. We are out of time. We will send that follow-up document, and you do have the contact information for these folks. In particular, I want to just reiterate, Tammy, the manual she was talking about is the manual from the Legal Aspects Training for DSS social workers. And if you can please email Tammy, rather than, she won't have access